to Crime on Court. My name is Heather. This is an update in the Delphi case. So we're talking about the Delphi homicides of Abby and Libby German and Abby Williams. I actually am planning on doing, just to let you guys know, I know it's been a while since I've done a Delphi video, so I wanted to get this out there. They just dropped a stack of docs, legal docs, so I want to read through those. But also, I wanted to let you know that I am working on a deep dive in this case, and I'm going to be doing um, more into like the episode that I have coming up is going to be like a who's who of Delphi because there's so many different people, so many different characters in this story, and I want to put together like a presentation for you guys on who's who of Delphi. So we're going to go through that, and just know I have other episodes, in the works where I'm planning on doing more deep dive coverage of this case, even though we're still going to continue with updates and reading through any documents as they drop. The unfortunate thing about this case is that we don't have access, video camera wise, to the courtroom. And they recently had, for this case, for Richard Allen, there was a 3-day hearing where they presented some evidence. I'm not even going to tell. They talked about several motions that they had still on the record. So I haven't even had a chance to really dive into those. So I plan on maybe doing like a video for each of the hearings, each day of the hearing. There was a 3-day hearing, so July 30th through August 1st. There were 3 separate days of hearings. I have notes. I have access to notes from multiple people who were there. So I can read through those for you guys and let you know what happened at those hearings because unfortunately we don't have video. However, that is going to be a bigger project. Those are lengthy days, and I just haven't had the time to really put into it with Karen Reid and everything going on in that case, and trying to get through Sandra Birchmore and other cases that I'm working on. So I'm doing like 5 cases at a time, which is hard to keep track of all of them. But anyway, so thank you for joining me. This is, like I said, an update regarding Richard Allen's defense. So recently, this was August 13th. Where did I say get April from? August 13th, 2024 is when these documents were filed within the Carroll Circuit Court, Carroll County, Indiana filing system. So what do they say? This is the defendant's supplemental submission regarding the state's motion in limine. Comes now the defendant, Richard M. Allen, by attorney Bradley A. Rossi, and respectfully requests that this court take judicial notice of the record of proceedings held in this cause on November 22nd, 2022, in the Carroll Circuit Court. In support of said request, defendant Allen states as follows. Number 1, on April 29th, 2024, the state of Indiana filed a motion in limine seeking to limit various forms of evidence in this cause. Specifically, paragraph 7 of said motion sought limitations on defendant's ability to introduce evidence of third-party culpability regarding the following individuals and/or subject matter. So this is their defense. Like this is their entire defense, and the prosecution is like, I don't want them talking about any of this. Okay. So yeah, a motion in limine is basically stating that they want to exclude or include certain things in trial. These are motions that they argue before trial begins. So these are the topics and or people, subject matters, individuals that they want kept out of the defense's defense, which is just absolute bogus. I think if that's your defense, how in the world can you stop someone from putting on a defense? But prosecutors try. All right, so Odinism, cult or ritualistic endings: Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Kline, Jerry Klein, and Ron Logan. So these are all other possible potential people or ways in which um, the uh, the crimes occurred. And these other individuals, they are possible suspects or whatnot, and never looked into. Their interviews went missing, things like that. So those are all, they also, several of them made confessions, or we have hearsay telling us somebody confessed. So there are obvious reasons why the prosecution wants to keep this out, but is it constitutionally okay for them to do so? Like, I have a real big problem with this. The whole state is against you. State government, you have two lawyers working for you that are public defenders, and it- they have all the weight against them of the world also that they're fighting against, and then you take away their defense on top of it. It's just ridiculous to me that that's even allowed to be argued in the first place. She should just like strike that. No. All right. So number two, the state's motion in limine sought to further restrict defendant's Sixth Amendment right to present his defense by way of limiting investigative records generated by former police officer Todd Click and geofencing records generated by law enforcement investigators. So the Todd Click is one of the officers, remember, that was still going down that path of other potential suspects, that like this Elvis Fields, Ned Smith, Johnny Messer, Todd Click, Ferenczi, Greg Ferenczi, and Kevin Murphy, all three of those officers were the ones that were still looking down that line of questioning, or investigating, even though Unified Command had been informed of them, and they didn't seem to really care. So Unified Command, I think, buried a lot of information. And the geofencing records shows that there were people in and out of that area, especially like during the search, or well, during the times of the crime that they say occurred, which I think is between like 2:30 and or 2 and 3, or 2:30 and 3. So they say that's when the girls' lives were taken. However, we have geofencing records and things that just don't add up if they were there in that spot at that moment, which nobody found them. So I don't think that there's just a lot of things that don't add up. Number three, on or about August 1st, 2024, so of this year, the parties appeared in the Carroll Circuit Court at which time both sides introduced evidence in favor of their positions regarding third-party culpability. The court took the issues surrounding third-party culpability evidence under advisement. As of that date, or as the date of this motion, no order has been issued in that regard. So she hasn't responded on that. Oh, go figure. Number four, the defense requests that this court take judicial notice of the record of proceedings held on November 22nd, 2022, and attached hereto as Exhibit A. One of the primary issues addressed at the November 22nd, 2022 hearing was the state's request to maintain confidentiality of the probable cause affidavit, charging information, and other investigative records. So it was the prosecution who wanted the probable cause affidavit sealed in the first place. And that's what they're arguing in that. Number five, at different times during the hearing, the state of Indiana, by prosecutor Nicholas McLeland, spoke the following words as it relates to the potential for third party culpability. This is still a very ongoing investigation. Our goal is to find anyone else who was involved in this heinous crime. That is the public interest, to find anybody else involved and get justice for Abby and Libby. But after he was arrested? Yeah. So he's even still talking about potential other suspects, anyone that might be involved. So there might be others that are involved here that talking about on November 22nd. He also says, we have good reason to believe that Richard Allen is not the only person involved in this case. So they thought there were more people involved, even when they arrested Richard Allen. So they never, when did they stop thinking that there were more? Have they ever made that public? No, not that I know of. All right, so Alan is not the only person involved in this case, and there may be other actors involved. That's why we left the tip line open. That's why we left the tip email open. The question becomes, at least in the state's mind, is it more important to release the details of the investigation to the public, or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible? He also states it puts the investigation in the best position possible to determine if anyone else was involved. It is in the best interest of the public that the investigation find anyone else involved. So, multiple times he has stated there's others involved. So, whether Rick Allen is or isn't involved, why are there not more people arrested? That's my question. Why are we just pinning it on one person? When McLeland, the prosecutor in this case, has said on record multiple times there's others involved. Number 6, the addition to the prosecutor's comments, the state introduced Exhibit 1 and Exhibit 2 attached in an effort to seek an order sealing the records. The first exhibit was a letter from ISP Detective Jerry Holman, and the second exhibit was a letter from Carroll County Prosecutor's Office investigator Steve Mullen. We're going to read both of those letters. 7. In pertinent part, Detective Holman's letter sought the sealing of the records for many reasons, one being that the investigation is ongoing and fluid. Number 8. The exhibit created by investigator Mullins cited that the matter was still being actively investigated. Investigator Mullen went on to state that law enforcement was continuing to search and seek facts and information relating to Richard Allen and other potential suspects. In this context, Investigator Mullen was concerned that the integrity of the investigation would be jeopardized if the content of the investigative documents was released to the public. And we've read that probable cause affidavit. There's nothing in there that would jeopardize the investigation. So I don't know why they keep calling or crying wolf. Like, no, no, we can't release it because it's so damaging to our investigation. No, it isn't. Nothing in there that's damaging or that could jeopardize the contents of their investigation. Number 9, Richard Allen had been arrested and jailed at the time of the November 22nd, 2022 hearing, yet the state acknowledged their pursuit of other suspects associated with these crimes. The state's own admissions are evidence of the existence of third party culpability in this case. And number 10, Defendant Allen requests that the court take judicial notice of the November 22nd, 2022 proceedings, exhibits entered during said proceeding, and ultimately deny the state's request to limit third party evidence pursuant to paragraph 7 of the state's motion in limine, file marked April 29th, 2024. And that's signed Brad Rosie. All right, so here are, let's start with the letters. All right, so dear Honorable Judge Francis C. Gull, I am Jerry D. Holman, a first sergeant with the Indiana State Police. After graduating the Indiana State Police Academy, I was assigned to the Lafayette District in June of 2021. Hang on, I'm making this bigger. My eyes are not that good. And for you guys, it's probably better to shrink it one more. That's better. All right, so I have been With investigations for several years, I was assigned as a detective in 2006, and in 2015, I was promoted to sergeant of investigations. As the investigation squad, okay, so remember, Jerry Holman is the lead detective in this case, just saying. He's the first sergeant with Indiana State Police, and he's the lead detective in this case. As the investigation squad sergeant, I supervised the detective's day to day activities. In 2016, I was promoted to first sergeant and assigned as the district investigative commander. As the DIC, I review and manage all criminal investigations at the Lafayette district. I responded to the Abby and Libby investigation to assist the Carroll County Sheriff's Department and continue to assist with the management of the investigation. He really thinks highly of himself. He had a lot of things he had to say about himself there. It is my professional opinion that the probable cause affidavit should remain confidential. There are many reasons for this. One reason is that the investigation is ongoing and fluid. New information comes in daily. All this information needs to be protected. But your probable cause is already written, so what do your tips have to do with anything? By keeping the probable cause confidential, this will let individuals know that they are protected and can share freely without worry of retaliation. The probable cause is already written, so what's the difference? And there's nobody in the probable cause affidavit. They talk about a couple of individuals on the trail that they interviewed, some girls, some minors, but I don't believe they even share their names. I think it's all redacted. So I don't understand what's not being protected here. By keeping the probable cause confidential, it'll let individuals know they're protected. But by not releasing the information, it will protect the integrity of this investigation and everyone involved, including Mr. Allen and his family. How does keeping it quiet protect Mr. Allen and his family? I don't understand. All it does is cause speculation. Nothing, PCAs should not be sealed. All this stuff in Idaho 4 and in Delphi where things are sealed, it's not normal and it shouldn't be. Courts are supposed to be public. And why there's so much secrecy in these cases, these high profile public cases, don't know. Additionally, confidentiality will help ensure that witnesses are not harassed by the media and social media. Since this is a nationally known investigation and has been the center of so many news stories, the interest of this investigation is widespread. Many well meaning people have numerous questions about the investigation. Due to the many questions those well meaning people have had in the past, many false accusations and information has been put out there in the public. No, because you haven't given any information, people are speculating and putting out false accusations and information. And it's caused issues for innocent people. This also causes problems for investigators with trying to investigate the facts. The media and social media outlets have posted side by side photos of innocent people who have adversely affected their lives. I'm concerned they will do the same to our witnesses, Mr. Allen and their families. No, you don't care that they're going to do anything to Mr. Allen or his family. You're just saying that to make yourself look good, that Detective Holman, because you couldn't care less about Mr. Allen or his family. This could be a heavy mental burden on them to be interrogated by so many news, media, bloggers, social media groups, and others, the general public, blah, blah, blah. The physical safety of others is important to us. We have a duty to protect everyone involved and the viability of this investigation. Yeah, physical safety of everyone involved is really on everyone's mind when they have Richard Allen in solitary confinement and in very dire conditions. Yet we're supposed to believe that they have safety on everyone's mind. Sure. If we do not protect the witnesses, other potential witnesses may have a problem deciding if they will choose to cooperate. This could harm the nature of an ongoing investigation. We don't want to impede the flow of information that comes in for the safety of others. Don't you think you would get better better tips rather than just any kind of tip about anything? Like you might get more focused tips that might be more efficient, a more efficient use of your time rather than just any old person calling the tip line. But if you give them information about the investigation and say, we're looking for your help with this specific thing, that's a lot better than just saying, here's a tip line, call us with any information you have. We can protect the investigation, witnesses, suspect, and all the family members by keeping the information confidential. And that is signed Jerry D. Holman, First Sergeant, District Investigative Commander, Indiana State Police. Next letter is from Stephen Mullen, who is from the Carroll County Prosecutor's Office. So he is an investigator for Carroll County, not he's a county cop, basically. So they're state, county, and town cops, right? So like Delphi have their own police department, and then they've got Carroll County, and then they've got Indiana State Police. It's weird because we don't have that middle level in Illinois. But anyways, where was I? Oh, I didn't even start it. Sorry. So this is regarding the confidentiality of probable cause for the arrest of Richard Allen. Dear Judge Gull, I am an investigator with the Carroll County Prosecutor's Office and a lifelong resident of Carroll County. I am the Delphi Police Chief when the double homicide he was the Delphi Police Chief when the double homicide of Liberty German and Abigail Williams occurred. I served 24 years as the deputy with the Carroll County Sheriff's Department and was a detective with the department. I have never been involved in any investigative process as complicated and intensive as this. As the court is aware, the affidavit for the arrest of Richard Allen contains information relating to the process of this investigation, witnesses, facts, and sources of those facts. Uh, isn't that what all probable affidavits should have? Not necessarily things relating to the process of the investigation, but I don't think there is anything in the affidavit about the process of the investigation. Just what they've uncovered so far is in the PCA. This matter is still being actively investigated. We are continuing to search and seek facts and information relating to Richard Allen and other potential suspects. If the content of the document is released at this time, the integrity of the investigation may be jeopardized. This case information, accurate or otherwise, has been widely published in traditional media and social media outlets. Release of information by the media has confused and created inaccurate tips and information. No, it hasn't. Keeping it a secret has. My blood pressure is boiling. All right. In my opinion, the release of information contained in this confidential document would only serve to complicate and frustrate the process of gathering truthful and accurate information at this time. Therefore, I respectfully ask the court to continue to the confidentiality granted to the probable cause for Richard Allen for an indeterminate time, meaning no determined end date, allowing the investigators to complete the follow-up process. What? What? I don't understand how not releasing it hurts their investigation. All right, we're going to move on to the next exhibit that they have, which is actually the first exhibit that they mentioned, which was A or I1. Nope. So here, this is the proceedings held on November 22nd. They're just asking her to take judicial notice of it. So basically, the judge takes note of it on the record, like, yes, I've noticed it. Okay, so one of the primary issues addressed at the hearing was the state's request to maintain confidentiality of the PCA, the charging information, and other investigative records. So we're going to read through some of this. I want to get through it quickly because, hold on one second. All right, we're just going to do this. All right, so proceedings. The court says, we are on record. Good morning. Nicholas McClelland says, good morning, Judge. The court continues. Good morning, ladies and gentlemen. Welcome to Carroll Circuit Court. As Officer Bodie has indicated, my name is Fran Gull. I am the judge in Allen Superior Court in our criminal division up in Fort Wayne, Indiana. I am serving as a special judge in the state of Indiana versus Richard Allen. I was appointed November 3rd on this year by the Indiana Supreme Court by Chief Justice Rush. I will show that the defendant is here in person with his attorneys, Mr. Bradley Rosie and Mr. Andrew Baldwin. Hold on. The dog needs a blanket. Sorry. Okay. So she was appointed by Justice Rush. I will show that the defendant is here, the state is here by the elected prosecutor, Mr. Nicholas McClelland. We are here today on the state's verified request to prohibit public access to a court record. So the state asked for this hearing because they wanted to seal this. That was filed on October 28th of 2022. Before we begin, I just would like to inform those of you present here in the courtroom of the courthouse management and decorum that was entered into the hearing November 22nd that I entered with the court on the 18th. The attorneys received this order so they know what to expect, and you've already, ladies and gentlemen in the gallery, experienced some of the directives. Only one entrance to the building was open. You were searched, your bags were searched. If you have your cell phone here in the courtroom, again, please ensure that that cell phone is off. I can't believe cell phones are even allowed in courtrooms. Like, the courthouse by me, like you get searched on your way in. You have to go through metal detector, and if you have your cell phone, you have to go back and put it back in your car or whatever. Like they won't let you in unless you're a juror or an attorney. So when I'm watching court and other like someone's cell phone goes off, I'm like, oh my God, how dare they? I don't know. It's odd to me that they still allow phones in courtrooms, but whatever. All right, so uh, I will tell you, consistent with my practice in Allen Superior Court, if your phone goes off, I will have it confiscated and it will be destroyed. Whoa, destroyed? Destroyed? Really? Ladies and gentlemen, please remain seated throughout the proceedings as we go through this hearing this morning. If you must leave, please do so quietly and please do so with the least amount of disruption possible. Once the hearing is concluded, I would ask that you remain seated until the parties and the court have left the courtroom and courtroom security indicates that you may leave. Mr. McClelland, on October 28th of this year, the Carroll Circuit Judge granted your verified request to prohibit public access to a court recorder and ordered the charging information and the probable cause and other court documents sealed and deemed to be a confidential court record pending public hearing. That order scheduled November 22nd at 9 a.m. to be that public hearing. Under the Indiana Rules of Court, the rules on access to court records that were effective January 1st of this year, the burden is on the state of Indiana to demonstrate by clear and convincing evidence that the requirement of Rule 6, Paragraph A, have been satisfied. Since we are proceeding under the Indiana Rules of Court, the rules of access to court records are not applicable. The Access to Public Records Act under Indiana Code requires the state to proceed under the rules of trial rules, so we will be proceeding under that. Therefore, no public testimony or comment is necessary, as that is only required under the Access to Public Records Statute Title 5. So, gentlemen, are you ready to proceed? Attorney Rosie says, yes, ma'am. McClelland says, yes, Your Honor. The court says, all right, Mr. McClelland, you may proceed. Mr. McClelland says, Thank you, Judge. As the court mentioned, the state did file a verified request to keep the records confidential and specifically the probable cause affidavit and the charging information. The state's proceeding under Rule 6, and what Rule 6 says, Judge, is in extraordinary circumstances, if the state showed that public interest will be substantially served by prohibiting access or the access will create a substantial risk of substantial harm to the state or other persons or the general public or that is prejudicial, substantial prejudicial effect to ongoing proceedings cannot be avoided without prohibiting access. The court can restrict access to those records. As the court said, the burden's on the state. I must show by clear and convincing evidence that at least one of those requirements are met. Doesn't have to be all of them, just one, Judge. And then, if the court does decide to keep the probable cause and charging information confidential, the court's required to do so in the least restrictive means necessary. So, Judge, in that effort, I have decided to present a couple of exhibits for the court to consider. I've presented those exhibits to the court, and I want to go over those exhibits, Judge. I've presented those to the defense. I have in court today as well. Exhibits what's been marked as States Exhibit 1 and 2, Judge, those are affidavits from Exhibit 1 is ISP Detective Jerry Holman, and Exhibit 2 is from the Carroll County Prosecuting Officer Steve Mullen. They've both been involved in the case for several years. They have intimate knowledge of the details of the case. They both believe in their affidavit that it's not an affidavit, it's a letter. Come on now. It's not an affidavit, that releasing information would jeopardize the ongoing investigation. The next exhibit, Judge, is States Exhibit 3. That's a letter from Becky Patty. That is Liberty German's guardian. She's in favor of keeping the records confidential as well. And then Judge Exhibit 4 is an online petition that circled not only the county, the state, and the nation. There's over 40,000 signatures on that petition, also petitioning the court to keep the records confidential. Why? What business is it of theirs? The state's moving to admit those 4 exhibits, Judge. So, I don't understand why 40,000 signatures care so much about keeping court records secret. I don't know, sealed. I would think it would be the opposite. We would want transparency. Court says any objection from the defense. Rozzi says no, ma'am. The court says, Jody, I'll have you mark those as States Exhibits 1, 2, 3, and 4 as reflected by Mr. McLeland, please, and show those admitted without objection. They were admitted. Mr. McLeland continues. Thank you, Judge. Judge, there's not a lot of precedent for a hearing like this. I've searched high and low for case law, talked to several people. There's just not a lot of precedent. This is an unusual situation, an extraordinary circumstance, if you will. The state is confident in the evidence that's been presented in both the probable cause and the charging information. We're confident of that evidence and of the contents, but I am concerned. I have 2 concerns: the continued investigation and then protecting the witnesses involved in that case, Judge. Those are my 2 concerns. So the continuing investigation and protecting the witnesses is why they chose to seal the probable cause, which when you read the probable cause, as we have, there's nothing in there that could mess with their investigation or harm the witnesses. All right, whatever. It's my job as prosecutor, in part at least, to enforce the law in an effort to protect the community. It is the public interest for me to enforce the law to protect the. Oh, sorry, no, they wrote that twice. Okay. The first concern talks about the integrity of investigation, and I think that falls under the public interest factor and consideration for the court. This is still a very ongoing investigation. How many times is he going to say that? My goodness. How many times are ongoing investigations still happening and probable cause affidavits are still made public? They don't correlate. They don't relate. I'm sorry, I just don't see it. The first concern talks about the integrity of the investigation. Da, da, da. This is an ongoing investigation. Our goal is to find anyone else who was involved in this heinous crime. This is in the public interest to find anybody else involved and get justice for Abby and Libby. We still get tips every day. Tips come in every day. We have good reason to believe that Richard Allen is not the only person involved in this, that there are maybe other actors involved. That's why we left the tip line open. That's why we left the tip email open. Find other potential suspects. The question becomes, at least in the state's mind, is it more important to release the details of the investigation to the public or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible? The public has an absolute right to the information. I don't deny that, Judge, but at what cost? This rule was denied for extraordinary circumstances where the court can limit that access. The state believes that this is one of those extraordinary circumstances. Keeping the record confidential serves the public interest. It puts the investigation in the best possible position to determine if anyone else was involved. It is in the best interest of the public that the investigation find anyone else involved. How many times is he going to say that there are more people involved? The second part that he keeps repeating himself that this is an ongoing situation and there's more people involved, apparently. Second part that I'm concerned about, Judge, is the safety of the witnesses and other people involved in the case. We have seen the extraordinary lengths the media has gone to in order to get the next soundbite or the next clip for their broadcast. We are a society of people that has to know right now. Social media, Facebook, Instagram, we want all the information right now immediately. What does that have to do with the fact that probable cause affidavits are not usually sealed unless extraordinary circumstances? Makes no sense to me. We've had social media for how long? And we're still doing court cases without sealing every probable cause affidavit. The media has went to great bounds to interview anybody involved in this case. Mr. Allen's wife, Mr. Allen's old neighbors in Mexico, they've staked out his house. They've went to these extraordinary circumstances to get anything they can involved in the case. Even by Richard Allen's own admissions, a letter to the court asking for a public defender, they forced his wife to move and abandon their home. So he had his poor wife is, who knows where she's living now. We also know the prior judge, Judge Diener, recused himself by his own admissions to an email to the court judicial staff. He had concerns for his safety for his staff due to the facts surrounding the arrest, so much to the point where he felt it was necessary to get out of the case, Judge. Nick McClelland just admitted that. Judge Diener recused himself by his own admissions to an email to the court judicial staff. He had concerns for his safety, the judge in the case. He was the original judge. Judge Gull was not the original judge. He had concern safety for his staff, for his safety due to the arrest, so much to the point where he felt it necessary to get out of the case. And so the state believes these are real concerns for the witnesses and the people involved in this case. So let me take that back a little bit. Let's say people were threatening Judge Diener to make sure that Richard Allen got put away, even though the evidence doesn't show that he's the guilty party, even though there is no probable cause if you're not lying on your probable cause affidavit. Maybe he knew Richard Allen was not guilty, but he was being threatened to make sure he got charged and convicted for it, perhaps. And that's why he recused himself. I don't know, I'm speculating. This is all speculation, but it says right there, Nick McClelland's own words, he admitted for fear of his own safety and safety of his staff. I don't know. This whole case stinks. All very shady stuff. And so the state believes there are real concerns for the witnesses and the people involved in this case. Look at the amount of security we have here today, Judge. We don't have a lot of security in Carroll County, but I can tell you my tenure here, I've never seen the display of law enforcement that we have here today. This is a highly publicized case. We've had countless meetings over the couple months or past month about security, how to get Mr. Allen in here, all for the safety of everybody involved in this case, Judge, and you should extend to the witnesses and should extend to the other people involved in this case. The court can imagine the media pressure, intimidation, and evidentiary issues that may arise if the name of the witnesses are released and those witnesses are subject to constant harassment and bombardment by the media. Simple solution: redact their names. That's all you got to do. Say witness one, witness two. You don't even have to say their names in the probable cause affidavit. You can just say witness A and B, witness one and two. Either way. All right. The state also has concerns that they may be interviewed on the 6 o'clock news and their testimony will be taken as such. What? Constant harassment and bombardment from the media. The state also has concern that they may be interviewed on the 6 o'clock news and their testimony. It's not testimony if you're talking to somebody on the news. Will be taken as such that causes evidentiary issues because a witness talks to the media. Some of the witnesses were juveniles at the time. They are now 19 and 20. You know what? A witness can talk to the media all they want. And to try to put a gag order on that is a little ridiculous. At this point in time, they've already done the investigate. Like, come on. They're not still questioning these people, are they? Some of the witnesses were juveniles at the time. They are now 19 and 20 in their first and second year of college. They need to be able to focus on what they're doing in school and not be worried about the constant harassment of media. Who effing cares? I don't care about them concentrating on school. If they're witnesses to something and they have important information that they can provide to the conversation, they should be out there saying it. They shouldn't be told by law enforcement or the prosecution not to talk to the media. This is making me angry. Sorry. I got real mad about that. This is like trying to silence our First Amendment right to free speech, to talk to the media, to speak up against the government when they're doing you wrong. And I'll remind you, Judge, some of the witnesses are still juveniles, and so there's concerns there. You just told us they're 19 and 20. They're not juveniles anymore. They're adults. So again, why? Are we trying to pretend like he's just lying? He's saying they're juveniles when he just said they're 19 and 20 now. Again, Judge, the burden is on me. I have to show by clear and convincing evidence, and so the gauge starts at the presumption that the information should be released, and I have to convince you to move that ticker far enough to keep it confidential. And so, Judge, I looked up clear and convincing. We don't deal with it a lot. We deal with beyond a reasonable doubt, and so I looked up the jury instruction for clear and convincing. The jury instruction says the facts supporting the claims are highly probable. Look what we have here today, Judge. The chaos, the amount of attention that this has drawn, the concern for safety, defense counsel, the state, everybody has had a concern for safety for themselves, for Mr. Allen, for everybody involved. Went to extraordinary lengths to protect everyone here today. We can't look at this case like any other. This is an extraordinary case it is by its nature. The state believes it's important, but why? Are you saying it's so extraordinary? Why? How is it? He doesn't explain. The state believes it's important and allowed under Rule 6 to keep the PC and the charging information confidential, not only to provide the integrity of the investigation, but also to protect the witnesses in the case, Judge. So the state respectively would ask the court to continue to keep the PC and the charging information confidential. However, if the court deemed that those items should be released, the probable cause and the charging information, I would ask the court to consider redacting the witnesses' names to protect their identity and the people involved in this case. In an effort to do so, Judge, I have a redacted charging information and probable cause that I'd like to submit to the court for their consideration. Why didn't you just give it? He has it already redacted. Just publish that version. It has the names of the witnesses and the people involved in the case redacted. And if the court's so inclined at this time, I'd like to at least admit that to the court, not as an exhibit, but as for consideration for the court to consider a redacted version as opposed to releasing the entire document. The court says, "Any objection, gentlemen?" Rosie says, "No, ma'am." The court says, "Okay, thank you. I won't mark this as an exhibit. This will be my work product, so I'm not going, so it's not available to anybody other than myself and my staff." Mr. McClellan says, "Thank you, Judge." So, Judge, why does he say Judge so many times? So, Judge, I'm about done. I wanted to leave you with this one last thing. As I said, I did a lot of case law research and find any support of my motion or anything that is not in support of my motion. I came across a case, Brown versus State, Indiana Supreme Court case. It's from 1969. It's old, but I wanted to read you a quote from that case because it kind of hit home dealing with the circumstances that we have today. And the court says this: "The right of the news media to fairly and accurately report the news, the right of the defendant to a fair trial before an impartial tribunal, free of influence of generated prejudice and inflamed passion of the community, and the right of citizens to fully comprehend and analyze the administration of the court system are elements necessary to the attainment of justice. Elements necessary to the attainment of justice. If any one of these rights fall, the rest will surely fall, and the term justice will become hollow and meaningless in our constitutional system." Judge, again, the state's asking that you keep those things sealed. I appreciate the time here in court today, and I appreciate you allowing the state to have entered exhibits and make an argument. Thank you, Judge. All right, that was Mr. McClellan. She says, "Thank you." Now, Mr. Rosie's turn. All right, Mr. Rosie says, "Thank you, Nick. Judge, let me just start by saying that Mr. Allen in this case seeks transparency. It seems to me that in the normal course of operations in our courtrooms around the state, and that's what we get. That's the norm. And really, there's no reason in this case to stay away from that. I would point out first, if I could direct the court to the pleading that was filed on October 28th, 2022, the verified request to prohibit public access to a court record. This pleading, if you look at it, is deficient on its face, and I would direct the court specifically to the fact that Rule 6A specifically says a verified written request to prohibit public access to a court record may be made by any person affected by the release of the court record. It requires a verification. And a verification in our business that word is a term of art, as you know. 1145 codifies the very essence of what a verification is. And what you're going to find, and I would direct the court to Smith versus King. Excuse me, it's a little dark in here, frankly, blah, 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 whatever number that is. It's a 1999 case involving an election dispute. Specifically, Head Note 3 of that case addresses what a verification is and what the minimum standard to meet the verification is. And it says, when applied to pleadings, verified means supported by oath or affirmation in writing, pursuant to Trial Rule 11b. It's sufficient if the petitioner simply affirms the truth of the matter to be verified by affirmation or representation in substantially the following language. And it says, quote, "I/we affirm under penalty for perjury that the foregoing representation is or are true," end quote. The essential purpose of a verification is that the statement be made under penalty of perjury. And it cites Austin versus Sanders, This document contains no verification which references that that it's been signed under the pains and penalty of perjury. So I think it's facially deficient, and I would ask the court to consider that before we even get to the rest of this. And of course, I can offer up the case to the court, but I know you have the citation, so we should be good. Moving on, we get to the access to public record statutes, whatever, 51431. Open door law, all those kinds of phrases that get thrown around in our practice. And what I would say to you is that, I actually, when I look at when I take a look at the statute, I was actually surprised to find that the very first section, the first chapter, codifies public policy. And I think that's extremely rare in our practice when you actually see a statute that essentially codifies the public policy. And I'm not going to read the whole thing, Your Honor. You've probably already looked at it, but the first sentence says a fundamental philosophy of the American constitutional form of representative government is that government is the servant of the people and not their master. Ooh, I love that. It sounds like something Thomas Jefferson wrote, frankly, but more importantly, you get to the last sentence and it says this chapter shall be liberally construed to implement this policy and place the burden of proof for the non disclosure of a public record on the public agency that would deny access to the record and not on the person seeking to inspect. It says two important things. One, liberal construction, which means it pertains to many documents in our judicial system. And two, most importantly, it places the burden of proof on the state in this case, which Mr. McLeland has already acknowledged. And that burden of proof is, of course, the clear and convincing standard. So I think the point I'm trying to make here is that the legislature felt so strongly about the disclosure of public records that it actually codified the public policy. I just think that's really unique, and one of my counterpoints that I practice with would say that's pretty cool. It's not just the kind of law that we're used to seeing. So moving on, this Rule 5 is kind of the driving force here, actually, in this access to court records arena that we're in. And the Rule 5 basically says that, exclusion up front is, or I'm sorry, that transparency up front is where the court ought to be with this, and only under extraordinary circumstances should the court deviate from that. I mean, that's pretty much how I feel too, that it should only be extraordinary circumstances that they would deviate from allowing documents to be public. And that word extraordinary is the second word in Rule 6 too, by the way. And what you see if you read through these rules is that there are a lot of terms that are used that just really bolster and beef up that burden of proof, and think they just speak to how important it is that we have transparency in this community, in this system, I should say. Different and that's no different in this case. So let's get to Rule 6. Mr. McLeland hit on a couple of bullet points, one being that the public interest is substantially served by prohibiting access. Again, another strong word, substantially. Disclosure of the records will create a significant risk, again, and a significant risk, a substantial harm to the prosecutor, other persons, or the public. Disclosure will work some prejudicial effect on the ongoing proceedings. So, yeah, how is it going to substantially harm the prosecutor by putting this out, or law enforcement by putting it out there? I don't think it will. All right, so all strong words, again, consistent with the clear and convincing standard. Let's touch on the first one specifically. Will the public interest be substantially served by limiting access? And Mr. Allen's position is no, it will not. It's exactly the opposite. This is a case where the crime occurred over 5 years ago. It's taken almost 6 years for an arrest to be made. Time and public resources have been exhausted over the scope of time. Those are almost impossible to quantify, and any secrecy involved in this investigation, in my opinion and Mr. Allen's opinion, has done nothing but increase the hype and the public interest. I agree. I mean, it's the idea that the public has known very little is what has caused, all this attention to occur. And so, by continuing that pattern or allowing the state to maintain this confidentiality, I think we're just perpetuating the problem. My suggestion is that the opposite would happen if you unseal the records. Holy moly, what a concept. Unseal the records and maybe people won't be speculating so much. And that is to say that the public can see the truth regarding the facts that support the allegations in this case. They can see where the expenditure of their tax dollars has gone. And Mr. McLeland talks about the second prong here and that the release of the records will create a significant risk of substantial harm to the prosecutor, other persons, or the public. At this point, I don't want to sound flippant, but what's the risk? I mean, we've all just walked in here today, with security and the right safeguards in place, and we're fine. There are a few juveniles referenced in the affidavit, and I do understand that that may play a little bit larger role in the court's opinion today, just trying to protect those individuals. And frankly, Mr. Allen, the defense, doesn't have any problem with redacting some names of witnesses and things of that nature that do. Um, that might serve a purpose. But, I haven't heard and nor have I seen in any of these exhibits that were introduced by the state any actual references or appreciable threats that have occurred. So he really didn't say any specifics. Like nothing, there have been no threats. Threats aren't happening. So why are we keeping it a secret still? You know, like he says, in other words, we didn't hear John Doe or, Jane Doe come in here today and tell you that they received a phone call from an anonymous person last week with a threat on their life. I haven't heard an officer say that he or she has been, their lives have been threatened. I don't think a lot of this is just driven by the social media aspect of this. You can get on Facebook any day of the week and find somebody threatening somebody. Not that I don't take those things seriously, but it's like fast food. Most of that doesn't have a lot of quality to it, just quantity. And I haven't heard any evidence today other than some argument about the law, which actually supports the idea that there are any appreciable threats or on anybody involved in this case. And so, my suggestion at this point regarding this second prong, that there'll be some significant harm to the public or people involved, I think is just conjecture and speculation. I agree. Moving on, there's a practical problem here too, and the practical problem is if the court orders these records to maintain confidential or to remain confidential, we're gonna be forced to walk into this courtroom and delicately dance through all the factual scenarios in this case because the public's gonna be sitting behind us, and that doesn't seem to make any sense. Right, like you're going to be kind of like secretly talking about everything when if you just put it out there, then you can be open in your hearings about it too. Where was I? You're going to have people reading between the lines, all this stuff's going to go down in print and then you're going to have all these, the public trying to decipher what we did and didn't say and what we're inferring. And, it makes our job way more difficult. I would argue that it's going to make Mr. McClelland's job more difficult. How do we talk about law and facts in a bond hearing? We've got a bond motion pending. This was forever ago, so yeah, we don't anymore. But how do we talk about laws and facts and in the suppression hearing? How do we talk about law and facts in a hearing on change of venue? All those things, which are pretty customary in cases like this. The public would be sitting right here the whole time, and so it just doesn't make any sense practically either. And I'll just finish with this. The burden again. We've talked about the clear and convincing evidence. I haven't gone back and counted. I didn't, do any internet searches before I came in here today. But over the last 5 years, I have some very ingrained memories of state police press conferences in this community. I don't know if there were two or four or six or eight or 10. I frankly don't know. It seemed like a lot. And frankly, there was a lot. Because as I've gone through trying to like find them and watch them, there are many and it's confusing. And they definitely did one like every year for 5 years before they arrested Richard Allen. They did at least one press conference a year about the case, if not like, other news media and whatnots that they did, but they at least, set up press conferences once every year. All right. And in my mind, for the state to come and for the state to be a part of the process of having public press conferences, releasing composites, things of that nature, and asking the public for help, and then to turn around today and suggest to the public, we don't really want you to see what's here. It's kind of like talking out of both sides of your mouth. I mean, that's the way I view it. And I think that's the way Mr. Allen views it. And, we think that the standard is extremely high here, clear and convincing evidence. Nick gave me a little crash course on what the Black Law Dictionary says. What I know about clear and convincing evidence is for those of us that practice in civil court, from time to time, it's the standard that we employ when we're trying to terminate somebody's parental rights, which I think is a pretty darn high standard. And to say that the state has met that burden in this case, I think is just not accurate. None of these documents that you've seen have any information in them which suggests anything with detail that somebody's in harm's way and that some other suspect is, out there and needs to be apprehended. It's just conjecture, and we would ask that you unseal the records, if you will, for lack of a better phrase, and let's move on with this. Thank you. Court says, "Any response, Mr. McClelland?" He says, "No, Your Honor." The court says, "Well, gentlemen, I really appreciate your excellent oral advocacy." She's so nice here. I will take the petition under advisement to review the exhibits that have been submitted, the case law that has been argued by counsel, and issue a written ruling in due haste. I know that this case has generated a lot of public interest, and I know that the attorneys and Mr. Allen deserve this court's attention as quickly as possible. I know with the holiday coming up, that will not interfere with my ability to review my notes and the exhibits and issue a written ruling. Mr. Rosie, you and Mr. Baldwin did file a motion or a petition to let to bail. Can we set that for hearing? Okay, so then they go on and like schedule some more stuff. I don't think we need to continue reading on, but I thought that that was kind of important to see. That was early on when they first arrested Richard Allen and talking about unsealing the probable cause. Well, it was sealed at that time. This whole time it had been sealed up until Richard Allen's arrest. And then they finally unsealed it. All right, this next thing I wanted to read to you. Oh crap, it's going to be too big. So recently, Judge Gull issued two orders. So I'll read this one below first because this is the docket, I think, right? No. Okay, this is the first one. All right. So the court so this is the court's order regarding the Frank's third and fourth Frank's motions. So the court, having had Richard Allen's third Frank's notice and request for Frank's hearing based upon newly discovered evidence and request for findings of fact and conclusions of law upon any ruling of the request, the state's response to defense's third motion for Frank's hearing and the defense's reply to the prosecution's response to the third, she's just listing all of the different things that she read regarding this. She took all those under advisement, now denies the third request for Frank's hearing without hearing. The court finds the affidavit submitted in support of the issuance of the search warrant contained information that a reasonable belief existed that evidence of the homicides would be found in the defendant's vehicles and home. The affidavit did not contain false statements. Yeah, it did. Nor did the affidavit omit statutes with reckless disregard. Further, the court does not find the affiant intended to mislead the judge by failing to present relevant information. I find that disingenuous, but okay. And then her next ruling is down here. The court, having had defendant Richard Allen's fourth motion, or Frank's motion based on newly discovered evidence and request for a hearing, now denies same without hearing. The trial court is obligated to conduct a Frank's hearing only if the defendant makes a preliminary showing that the affiant, knowingly or intentionally or with reckless disregard for the truth, included a false statement in the search warrant affidavit and that the allegedly false statement was necessary to a finding of a probable cause. The defense has not made such a preliminary showing and therefore is not entitled to a Frank's hearing. I think that's BS. I think they showed plenty of evidence that there was some shady stuff going on with law enforcement, especially regarding this probable cause affidavit and the original investigation into the Odinists or Odinites, whatever you want to call them. Finally, um, just to wrap up here, I gotta head out quick because my boyfriend just got home and the dogs are gonna get loud. So, real quick, we have a status hearing scheduled for when is it? Sorry, August 23rd at 1 p.m. in the Carroll Circuit Court. Basically, they're just gonna talk. Status hearings are often they often take place. They get scheduled for many reasons. So, I don't really know if there's a specific reason hearing that somebody requested, but for whatever reason, there is a status hearing August 23rd. It might just be to talk about scheduling for the upcoming trial. So let me know what you guys think. Let me know if you agree with Judge Gull's rulings, and I will see you guys in the next video. Make sure you hit the subscribe button and hit the like on your way out, and I'll see you guys in the next one. Take care. Have a good one.